Okay, our second case on the docket this afternoon is case number 23-2519, Caitlin Kristen Rodriguez versus Florida Success Management Group and others. Counsel for appellant, when you're ready.
May it please the court. My name is Nicolette Sambus. I represent Caitlin Rodriguez, the injured worker in this matter. She is, to say the least, a young individual who suffered a horrific incident and accident at work.
Counsel, would you like to reserve any time for rebuttal?
Oh yes, please, 5 minutes.
Very good,
Thank you. In this case, we have a young woman who worked as a server at Denny's. She was 21 years old. It was the 2 a.m. shift, and 2 patrons come in. They get involved in an altercation. One was shot in the chest. Our injured worker here runs to the aid of the victim, who is now dying of the gunshot wound to his chest. The facts in the brief are pretty laid out. They're pretty horrific. But the main argument here on appeal is the judge's failure to take into consideration the plain language of the statute. And here we're arguing that 440.093 was not considered based on the exact terminology that is written in the statute.
And one of the things I'd like clarification from you is, are you arguing compensability under the second sentence of 93.1 or paren 2?
Under the first section. So I'll read the statute to make it clear. So 093 subsection 1 says, nothing in this section shall be construed to allow for the payment of benefits under this chapter for mental or nervous injuries without an accompanying physical injury requiring treatment. Then it says, a physical injury resulting from mental or nervous injury unaccompanied by physical trauma requiring medical treatment shall not be compensable.
Well, why would compensability be appropriate under paren 2?
Why would it not?
Correct. I mean, if you didn't have the medical treatment issue or the as required medical treatment, don't you still have a compensability argument here under paren 2?
I think that there is an argument here under both, yes, but here we have under subsection 1, it's clear based on the terminology that we have, this is not a case where we're just talking about fright, excitement, or nerves alone.
But where was the medical treatment? I mean, it's undisputed that she was bruised when this poor guy was dying and grabbing onto her arm, right? But she didn't seek treatment for that bruise. So where's the medical treatment that triggers that second paragraph?
And that's my issue, Your Honor, is that the term is require medical treatment. It doesn't say that she has to receive medical treatment. It doesn't say that she has to even request medical treatment. The term is required. And the definition of required, it's not defined in 440, but if you look it up in the plain Oxford dictionary, it says to need, okay?
Would you agree that that goes to the physical injury, not the mental injury?
And that's part of my argument too, Your Honor, is that it says require medical treatment, I'm going to quote it again, accompanying physical injury requiring medical treatment. It doesn't say medical treatment for the physical injury. So there's 2 parts of the argument. The first part is that she immediately, once she was able to get out of her room because she was locked up in her room for days after this incident, unable to communicate what has occurred, and that's the undisputed testimony. We have undisputed testimony from the claimant, no issues with her credibility, her veracity, undisputed testimony from her brother regarding the traumatic incident that occurred, the physical trauma that she endured, okay? Then once she's able to compose herself, speaks to the owner, she immediately requests medical treatment. She requests treatment for her psychological injuries, her psychiatric injuries, and that was not provided. In fact, it took over a month before the adjuster in this case reached out to the injured worker. So yes, within that month time, most likely her physical injury, the trauma that she endured, resolved. But that doesn't mean...
Wouldn't the typical way to read that second sentence, accompanying physical injury requiring medical treatment, the requiring medical treatment modifies the accompanying physical injury just right before that?
I would argue that it doesn't, Your Honor, but even if you do read it as that's accompanying the physical trauma portion of the statute, we still meet the elements, okay? The definition of require is not request, is not receive. The claimant is not arguing that she requested treatment for her right arm bruise. I'm not arguing that, that's undisputed in the
Well,
testimony.
what evidence in the record is it that her physical injury, which is the bruise on the arm, required medical treatment?
The issue here is to need medical treatment. And even in the answer brief, Your Honor, that the employer carrier provided, they say the circumstances would be different even if she went to the emergency room and just got an evaluation. And that just because she didn't go to the emergency room should not preclude this injured worker from being able to get medical treatment. The statute does not say she was required to receive treatment. And then you go to the definition of treatment. What is treatment, right? So there's several definitions of treatment, but I think the most important definition is that it can be an evaluation. It doesn't have to be that she got a Band-Aid, got stitches. Doesn't have to be that a doctor poked and prodded her for the care. The definition of treatment includes anything to identify an injury. Here, it was identified, it was readily observable. So that goes to the other issue in the statute where the JCC, I believe, missed the plain language of the statute. The true statute and the intent of the legislator was not embraced here, and that is what we're seeking to be reversed.
Well, if you're looking at requires medical treatment, I think requiring medical treatment, I think it is confusing in that what standards apply. Is it because the claimant decides they need to seek medical treatment? Is it because by medical necessity they should have received treatment? Or do you also consider the claimant didn't have any money or didn't have insurance? So, justified, I would have sought medical treatment due to my pain, but I couldn't afford it. So how is that applied? How do you recommend that be applied?
Well, that's the issue, Your Honor, and the recommendation is that it's not that she received it. How I interpret it is that the language needs to be as it is defined. So you're right, Your Honor. In this situation, the claimant's testimony in the record is that she wasn't in the proper state of mind to receive treatment. That's similar to an injured worker who's not able to get medical treatment because her employer takes a month to report it to workers' comp and no one provides her care, and in that time she may have needed the care but didn't receive it, and by that time it had resolved. So it's no different than even in the McKenzie
What is the
case.
evidence on the record that she, just like what you said, that she required medical treatment but she didn't go get it even though she needed it?
Your Honor, you'll see Dr. Ruano's testimony. He is the psychiatric IME in this matter who provided the undisputed diagnosis of post-traumatic stress disorder and major depressive disorder. He states at page 68 of the record that the likelihood of her feeling the pain in this PTSD state is significantly lowered. Okay. And then you see the claimant's testimony herself when she's asked in her deposition, why did she not get treatment for her right arm trauma? She says, I wasn't in the proper state of mind. There is not a medical doctor, and I think that maybe that's part of your question, that indicated that a right arm bruise needed the care. But that's not what is necessary. That's not the standard here. The standard is we have an injury that's undisputed. We have a readily observable injury. Now in the JCC's final order, she makes reference to the fact that there's not a doctor that testified that she would have gotten significant care or
What
some
they're
type of treatment.
orthopedic eval? I mean, there's no time limit in the statute that says requiring medical care received within 30 days. There's no time limit. So would you argue that the orthopedic evaluation that was performed here, and that's in the record, focused upon the bruising arm, satisfies requiring medical treatment?
Yes, Your Honor, that's part of the argument that that definition of treatment was provided. When I was talking about the definition includes an evaluation. A, the claimant requested it via petition for benefits, so within the statute of limitations, there's no issue there, it's undisputed. The employer carrier sent her for an evaluation. That's the definition of treatment, getting an evaluation. The IME from Dr. Halpern indicates that he was not deposed because the claimant did not object to this ability of his opinion because he provided that evaluation for the treatment that she was required to receive for her physical trauma. We have an injured worker here that meets the elements, and yet the statute wasn't embraced. The plain meaning of the statute, the language that's specified, the definition of the terms, they were added, they were changed. The word required became received or request. That's not the term. She had a physical trauma. She has a contemporaneous, simultaneous injury involving mental illness and psychiatric needs. And in order for 440.015, the intent of the statute, the purpose of workers' compensation to come to fruition, for it to be embraced, then she has to get that care. She has to be able to return to work. This woman witnessed a horrible accident, was involved in this trauma, and yet now she is being penalized. And that's not the purpose of 440.015. I see that I'm in my rebuttal time, so if there's no questions, I'll take a seat.
Thank you.
May it please the court, Chief Judge, Your Honors. My name is Mary Frances Nelson, and I represent the employer carrier servicing agent in this matter. We're here today, and there is no dispute that this was a horrific incident that happened while the claimant was at work. No dispute. The claimant was witness to a shooting. She was there with the victim of the shooting. No one questions that at all, but while these are tragic circumstances, that's not something that we need to look at under Chapter 440. We have to look at this based on the black letter of law, not emotions, not physical, or not sentiments. Chapter 440 provides guidance for provision of benefits, and that's medical benefits and indemnity benefits based on facts and objective evidence. So in this case, we have to look at the facts and the objective evidence, and I ask you to set aside the emotional aspect because there is.
If you look to the plain language of the statute, I guess two questions for you. Why wouldn't this be compensable under Paren 2? And then secondly, how do you explain the sort of inconsistent use or verbiage in the second and third sentence of Paren 1 where we've got physical injury requiring medical treatment, and then the statute goes on to use physical trauma? So we've got two different terms, the use of trauma in the next sentence, which says physical injury resulting from mental or nervous injuries unaccompanied by physical trauma. Why do we have inconsistent terms there? Why is trauma left in the statute or written in, and then we have a physical injury reference?
Your Honor, first as to 440.0932, that is not applicable because that version of the statute indicates that the psychiatric or need for psychiatric treatment, the mental trauma, or the mental issues would arise from the injury. There is no testimony in front of this court that her need for psychiatric treatment was because of the injury. It was because of what she witnessed. The psychiatric IME testified that it was the need for treatment was because of what she witnessed. Wasn't the injury that was a bruise. The injury did not cause her need for psychiatric treatment, which is why 093 Parens 2 should not be considered. As to 440.093 Parens 1, this court provided a very detailed analysis in the McKenzie case, McKenzie versus mental health care, and detailed each of those sentences. So when that happens, and it states physical injury, physical trauma, there's nothing that says that the trauma doesn't, because if you use the word trauma or you use the word injury, it doesn't matter. The result is still the same. It has to require medical treatment.
But there's not that clarifier or that modifier after the physical trauma sentence or usage, correct? That same modifier is not after trauma.
Right. You wouldn't get to that sentence until you read the second sentence, which says nothing in this chapter shall require treatment without a physical injury that required medical treatment. So that stops. So if you're talking about the physical trauma, that's looking at the other aspect of 440.09.3 when you have potentially a separate physical injury and physical trauma that were part and parcel of a single event, and that's not what happens in this case. We ideally should stop at the first sentence of 440.09.3 because there was.
But McKinsey doesn't stop though, it gives us 4 categories.
Yes,
So
Your Honor.
It breaks it out, so assuming that we're bound by McKinsey, and I think we are, we've got four categories, so we can't stop at the first sentence, right?
Right, and Your Honor, to get to that, first off, I do want to mention that before you even get into these questions of psychiatric care and whether it's necessary, Judge Sansoni ruled in the lower court that there was not timely notice. That wasn't appealed. So really, we shouldn't even get to this point, because when Judge Sansoni ruled that there was no timely notice, that should stop the issue. No timely notice of the incident, no timely notice of the injury, stops the argument. Then, Judge Sansoni also went on to determine whether or not there was an injury. And in her ruling, she established that there was not an injury as defined by 440.09. Specifically, she discussed the fact that the requirement shows the injury must be established to a reasonable degree of medical certainty based on objective medical findings, confirmed by physical examination or diagnostics. And in this case, there was no evidence to prove that she had an injury, so there was nothing that showed within a reasonable degree of medical certainty that she had an injury. So without an injury, we stop at that very first sentence.
Well, I mean, she had an injury, she had a bruise, right? It's undisputed that she was injured, but she didn't seek medical treatment.
There is no evidence in the record that that was established within a reasonable degree of medical certainty that there was an injury and that it was caused by the work incident. What we know is she said that she had a bruise, but there is nothing from a medical standpoint that shows within a reasonable degree of medical certainty, which is required by 440.09, that there must be that magic language. So if you don't have an injury, then you stop at that very first sentence of 440.09.3. And that precludes psychiatric treatment when there is no injury. And in this court even provided a very specific example. And that's if a person were robbed at gunpoint, but they did not have a physical injury, then there is no compensable psychiatric treatment available for them. So in this particular situation, she witnessed the incident. Judge Sansoni found that there was no injury, so therefore the claim for psychiatric treatment should deny under that first sentence. The second sentence of the statute also reiterates that. And it says, nothing in this section shall be construed to allow for the payment of benefits without an accompanying physical injury requiring medical treatment. The appellant has conceded, it's listed in the argument, it's listed in the reply brief, it's listed in the evidence. The claimant did not require medical treatment. She stated that she had a bruise. That's what we know, that's lay testimony. But she did not require medical treatment. And without requiring medical treatment, we have to stop at that second sentence. However, to your point, Your Honor, in the McKenzie case, it also goes to the next statement, which is if there is a separate physical injury and mental injury. But again, you have to have medical care for that. And since Judge Sansoni ruled that there was no physical injury, then the mental injury can't be covered. And I've addressed 440.09.3 already, because there is no, the injury itself did not cause that psychiatric issue.
Did you, with respect to the estoppel or res judicata argument, that this discussion with respect to interpretation of the statute doesn't matter because this is all barred by the late notice of injury, did you argue that in your brief?
No, Your Honor. The point was addressed to the requirement for psychiatric treatment. The Florida legislature adopted the 2003 changes and added in 440.093 because it outlines the burden of proof to show by clear and convincing evidence and provides these guidelines. And in the lower court, the JCC found that this was done in order to provide some type of guidance. Prior to 94, you didn't really have a lot of guidance, and then in the 1994 statutes, they said these mental or nervous injuries must be established by clear and convincing evidence. But there was still a glut of issues and no real clear guidance as to what was or was not required to get psychiatric treatment. So the 2003 legislature adopted 440.093, providing these very clear guidelines as to what is needed in order to allow a person to prevail on a claim for psychiatric treatment. The appellant would have you look to case law that was entered prior to the existence of 440.093. She talks about Prawl Brothers versus Phillips. And in that case, there was a finding that there was an underlying physical injury. We don't have that in this particular case. In addition, the City of Holmes Beach versus Grace case was addressed.
I guess how would you define, how do you think that the appropriate application of requiring medical care, what is that, a layperson standard? Is it a medical standard? Does it mean in actuality or in theory?
Your Honor, I believe that require means necessitates. And in order to have that guideline, you must actually obtain medical treatment. You must obtain and have an evaluation by a medical provider to address whether or not there is an injury, as defined by 440.09, and to establish by objective, relevant medical findings within a reasonable degree of medical certainty.
Well, there's no time limit. So based on your raising of the untimely notice of injury, would you say it's 30 days just by policy application? What's the time limit?
It would be within the same as what happened. At the time of the injury, you have 30 days to report or to request the treatment.
So if she would have gone into the ER and said, I bruised my arm, even if the doctor would have said, just put some ice on it, you're gonna be fine, that would have been requiring medical treatment?
Not necessarily, Your Honor. There again, it still would fall under that 440.09, where the injury must be established by objective, relevant medical findings and must require treatment.
What if it's the other way around, somebody that's got a terrible injury that just doesn't like doctors and refuses to get it? Would that be something that would require medical treatment? And a reasonable doctor would say, you should go in for that, but the person says, no, I'm not gonna go in. That would be sufficient to require medical treatment?
No, Your Honor, because they didn't get the medical treatment. So they're gonna have to follow through with that statement and require medical treatment.
Making required and mean receive, which is a different word, right? I mean, so if a wound requires medical treatment, but somebody foolishly refuses, that would seem to be a different word than received or, acquired or lots of other, synonyms for actually undertaking the medical treatment.
Correct, Your Honor. And in that situation, if you're still going to have the medical evidence to prove that there was a physical injury. So unfortunately, if they don't go to the doctor and then there's no evidence or indication that there is an injury that required medical treatment.
What if she took an aspirin? What if she had testified in depo that I was sore, I was in such a state I didn't want to leave my house, but I was sore, so I took an Excedrin, I took a Tylenol. Does that equate to medical treatment, although self-administered?
No, Your Honor. I believe that you have to look at the fact that she did not follow through with medical care. She didn't ask for medical care. And she even testified, and the record states, and the initial brief and the reply brief, she did not require medical treatment. The only requirement was the issue in the claim for psychiatric treatment in this particular case. I believe that this court previously provided very detailed instructions in the McKenzie case. The JCC followed those instructions. The judge's ruling that there was no notice, number one, should stop the argument. And if not, the judge's finding that the claimant did not meet her burden to prove that there was an injury as compensable under 440, then we should stop the analysis at that point as well. Even if we don't stop the argument, there's no dispute that she didn't require medical treatment. She had a bruise. People bruise all the time. It does not necessarily, and in this case, she did not require medical treatment by her own admission. So while she may need psychiatric treatment, that is not as permitted, again, by the objective black letter of the law, because she failed to meet that essential requirement that she needed medical treatment. And therefore, we ask that this court uphold the JCC's denial of psychiatric benefits for the claimant. Thank you.
Thank you, counsel.
I'm back. Okay, I just want to clarify a few points that the employer carrier made. First, she kept saying that it's undisputed the claimant did not require medical treatment. No, it's undisputed that the claimant did not request medical treatment immediately after the accident. And then the answer is the claimant did not receive medical treatment after the accident. Those are not the definition that's in the plain language of the statute. The statute.
There's not any testimony, I think Judge Osterhaus was getting to this earlier, there's not any testimony from a doctor saying that you should have gone in for medical treatment on your arm.
That's not, Your Honor, that's not an element of the statute. The statute says a physical injury requiring medical treatment, right? First, I would argue that the claimant did require medical treatment. She required medical treatment immediately after the accident and was not provided that. But if you're
For the bruise?
For the psychiatric component, Your Honor, that's what she asked for immediately after the accident. She asked that to the owner. The adjuster took a month to call her back or to reach out to her about a work comp case. But the issue here is that if you're using the medical treatment as a modifier for the physical trauma, which I'm not conceding that it is, here she meets the elements. She checks the boxes, and yet she's still denied the benefits. Counsel raised the fact that the JCC found notice as an issue. 441.185. It has that subsection D that talks about exceptional circumstances within the scope of A or B to justify such failure, but we're not even there. Notice was established. The JCC makes it clear that the employer had notice of the accident. They watched the video of the horrific accident and the shooting. They saw the claimant come to the aid of the victim. The notice is not in dispute.
Do we know anything about the nature of the bruise? I would guess there are different degrees of bruising. I've heard of a deep bruise versus a surface bruise. Do we know anything about the nature of this bruise?
Your Honor, the testimony is, which is not ever argued or contradicted or the claimant's credibility ever called into question, is that she had a bruise on her right arm that was observable, readily observable, and that's my next point, is that it was readily observable by her brother who testified. There's no issue with the brother's credibility, veracity at the final hearing. The JCC, even the employer carrier does not argue that these were untruthful statements, that it wasn't readily observable, and that's the element. You go to Closet Maid, which is a Closet Maid versus Sykes, which is a hallmark case in workers' comp, right? That talks about how lay testimony can be used to establish the fact that there's an accident and an injury if it's readily observable. This is an injury that's not under the surface. This is on her arm that was testified to that she has it. There's no question that it was there. It's
We don't have any medical evidence that it's an everyday bruise versus some sort of bruise that needs medical treatment, that requires medical treatment.
Well, how do you define treatment? You have to look to the plain language of the statute, Your Honor, and the definition of treatment is not what you would use in everyday terminology where I'm going to go and get treatment for some sort of catastrophic injury or cancer or any horrible diagnosis. This includes identification, diagnosis. It doesn't have to be that she gets stitches. It doesn't have to be that she even gets an ice pack. It can be just an evaluation. And the employer carrier concedes in their answer brief that if she had gone to the emergency room, got an ice pack, said you're going to be fine, that the case would have been different. And that should not be the case because she meets the elements of the statute. The plain language should be embraced, Your Honor, and that's what we're asking for this court to do. If the plain language is not followed, if we do not accurately define the terms as they are, require does not mean request, require does not mean receive. She meets the elements. It's not fright alone. This is an accident where, I'm sorry, I'm over my time.
Can I ask one last question? Thank you, Chief. I'm concerned about the jurisdictional res judicata issue that's arisen. In looking back at the JCC's order, a denial, one of the reasons for denial is that there was late or no notice of injury. That's a compensability denial. If that denial was not appealed, how do we get to this issue?
The whole,
And it's not argued in the answer brief, but, you know, from a jurisdictional review, I have concerns about whether we get to the merits of this argument.
Your Honor, the entire order was appealed, including the notice portion. But the notice that the JCC finds relates to the right arm bruise. The claimant asked for 4 things. She asked for medical treatment for her right arm bruise. She asked for temporary indemnity benefits. She asked for authorization of psychiatric care and treatment that was recommended by Dr. Roano along with PICA. So the notice issue, and as I read the JCC's order, applies to the right arm. And I'm not here telling you, this court, that Ms. Rodriguez needs desperately to see a doctor for her right arm bruise that has, the testimony is that's most likely resolved. I'm here telling you that Ms. Rodriguez cannot go back to work, which is the intent of the statute, because she needs psychiatric care, and that was denied. Unless there's more questions, I'll have some.
Thank you, Counselor. That concludes, we just had 2 cases on the docket today. That concludes our sitting, so we're adjourned. Thank you.